Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court will draw near and give their attendance, and they shall be heard.
And that's everyone, Mark.
Wonderful. Good morning. Although we have a regular sit in our term of court, we have before it an admission ceremony that we're going to go forward with. So good morning and welcome to the candidates for admission to the New York State Bar Association. And also welcome to all the family members and friends that have, tuned in to watch this brief ceremony. Let me introduce you to the justices of the Appellate Division 4th Department who are on the panel today. Senior Associate Justice Nancy Smith from Rochester. Associate Justice John Centra from Syracuse. Justice Shirley Troutman from Buffalo. Justice Joanne Winslow from Rochester. And I'm presiding Justice Gerald Whalen. This is the day that you have all been waiting for. 4 years of college, 3 years of law school, all the studying, test taking, then that bar examination prep and the bar itself. You've gone through the character and fitness committee, and here you are today. All of the hoops you passed through successfully. So I congratulate you on your hard work and your determination. I'm sure that you have had help from family members, spouses, friends, parents, many of whom are watching today. Help both financially and emotionally. Without their help, your goal to be admitted to the Bar of New York would have been much more difficult, I'm sure. So I'd like to give you an opportunity to say thank you to those that are watching or tuning in. And let's give them a round of applause. Now, what I'd like to also tell you is I'm certain, as you're keenly aware, that there's history being made around you today. You're entering the legal profession at a time in which our country is facing both unprecedented public health crisis and an extraordinary level of social and political upheaval. The confluence of these events presents a unique opportunity for all of you, for this is a time in which the legal community has been called upon and will continue to be called upon to play a pivotal role in ensuring equal access to justice. So as you embark upon your careers in the law, which I'm certain will present you with a multitude of rewarding opportunities. I strongly encourage you to embrace the opportunity that exists today to make a meaningful difference in the lives of those most negatively impacted by the current circumstances. Now the time has come for the candidates for admission to be sworn in as attorneys and counselors at law. Mark Bennett, the clerk of the court, will administer the oath. Mr. Bennett, have these candidates been certified to the court for admission by the appropriate committee on character and fitness as possessing the character and fitness required by attorneys and counselors at law?
They have, Your Honor.
Please administer the oath of office.
At this time, I'd like to invite all the candidates to unmute your microphones, raise your right hands, and at the end of the oath, please respond, "I do." Do you solemnly swear that you will support the Constitution of the United States and the Constitution of the State of New York, and that you will faithfully discharge the duties of an attorney and counselor at law according to the best of your ability? Please answer.
I do.
I do.
I do.
Congratulations, counselors, and welcome to the bar.
I wish you nothing but great success in your career. Thank you very much. We are now adjourned.
Thank you.
You're welcome.
And we are on to the court calendar.
If candidates could please disconnect from the session, that would be great. Thank you.
The first case on for argument today, People versus Turbor. Counsel, welcome.
Good morning. Good morning, Your Honors. May it please the court, Catherine Friedman representing appellant defendant Jeffrey Terborg. Your Honors, given that the district attorney's office has submitted in this case, I will rest on my brief. I would just ask the court to pay particular attention to my second argument regarding the second felony offender status that appellant was sentenced to. I ask this court to give particular scrutiny to the second department case, People v. Puka, where the defendant was adjudicated a second felony offender, but the second department reversed and held that the trial court was required to provide defendant in that case the proper notice.
Very good, counsel. We'll be happy to do that. Thank you.
Thank you.
Case number 6, People versus Hawkins. Okay, we have everybody here. Please proceed, counsel.
Good morning. May it please the court, Carolyn Walther for Ernest Hawkins. If I may, I'd like to begin by addressing weight of the evidence and legal sufficiency, which I cover in point 2 of my brief. And here the people's proof was deficient on the critical issue of Mr. Hawkins' state of mind, whether he had the same intent as his co-defendant, Xavier Nelson, to commit these crimes. And here we would submit that the evidence showed at most that Mr. Hawkins knew Mr. Nelson, but did not rise to the level of showing that he intentionally committed the crimes that he was convicted of here.
Our argument is that the connection with the defendant and the person that actually committed the robbery, that there's no evidence of a connection with them before the person arrives at the car and after the robbery's already been completed.
That's essentially it. Mr. Hawkins did disclose that he had in fact been robbed by Mr. Nelson approximately 2 weeks before. And so he knew the name Xavier Nelson. He also knew that Xavier Nelson had robbed, I believe, his uncle at some point in the past, but
your point is knowing him, that's not enough. There has to be something that indicates that he was part of this, knew that he was going to commit the crime before the crime was committed.
That's exactly right. And particularly given that he had an explanation, Mr. Hawkins had an explanation for both his presence on the scene and why he drove the car, that he was being held at gunpoint and essentially being forced to do so. The evidence here didn't...
That becomes a credibility issue, whether the jury believes him or not. I'd like you to address count 3 for me. I understand your argument with the other counts regarding the robbery, but count 3 is when he got in, he fired the gun in front of the defendant, the other individual. He got in the car and he, of course, his story, he pointed a gun, he did what he had, but we had other witnesses testify that wasn't the case. And when he got in the car, the defendant knew the individual getting in the car had a gun because he just fired it and he had it in his hand. And he admitted that he had a gun. How about count 3? Should that be, why shouldn't that be treated differently than the other count, possession of a weapon?
Well, we believe that that there was no intent for either of those crimes here. Now, Mr. Hawkins may have heard gunshots. He was sitting in his car at the time, potentially. So he may have heard gunshots, but that doesn't...
If you believe part of the story, he said he pointed the gun at him. Didn't he say that? So he knew he had a gun before he got in the car. So that ship has sailed.
Yes, I believe that, but that doesn't provide the requisite intent to actually fire that weapon. And I think here, when you look at the jury's...
No. I don't think, unless I got the counts mixed up, I don't think it's the firing the weapon. I think it's possessing the weapon outside unless I got it mixed up with the other counts. I thought it was unlawful possession of a weapon.
I see. Maybe I'm sorry. Maybe I misunderstood.
Count 3 is possessing outside of his home or place of work.
Yes. Okay. I'm sorry. I misunderstood Your Honor's question. Again, if he did not have the knowledge of this crime before it was taking place, this was a rapidly unfolding scenario. We're talking about someone running down the street with a weapon and getting into Mr. Hawkins's car.
Well, counsel, on the count that you're being asked about, let me ask you this. Do you still have to, is it still necessary under Penal Law Section 20, which was charged here, I believe, that they demonstrate that the defendant solicited, requested, commanded, importuned, or intentionally aided that person to engage in that conduct? In other words, the possession inside the vehicle. And is there any evidence other than would be speculated to that he did any of those things?
I don't believe there is. And I believe the people's case was on the theory of intentional aid, essentially, but no, the requisite intent wasn't proved here beyond a reasonable doubt on any of the charged counts. And I believe that the jury's verdict itself here really shows that the convictions were against the weight of the evidence. They did acquit him of the robbery where the weapon was used against another person, and yet convicted him of the other counts where he had the intention to use the weapon against another person, where the weapon was discharged and hit the surrounding buildings. And so that was, I think the trial attorney described it as baffling. And I tend to agree from a logical point of view. That just didn't make a lot of sense to me. So I believe that also goes to show that the verdict was against the weight of the evidence. Unless Your Honors have any additional questions about the other points in the brief, I would just like to close by touching on the sentence here. Should the court see fit to leave the verdict intact, we would ask that the sentence be modified for the reasons we've set forth in our brief. And I do believe that the people concede that the sentence on the reckless endangerment charge should have run concurrently rather than consecutively with the others.
If
there are no other questions, then I will rest on my brief.
Thank you, counsel.
Thank you.
Counsel?
Morning, Your Honors. May it please the court. With regard to the weight of the evidence issue, I think you have to look to the fact that the defendant was backed into his cousin's driveway with the car running. He wasn't out of the car. Civilian witnesses who really had no horse in this race testified that the driver sat in the car. Immediately after the robbery, the defendant runs right around the corner directly in the direction of the vehicle. There's no altercation between the driver and the co-defendant. So at the outset, I believe the evidence clearly shows that he was the getaway driver. And if he was not the getaway driver in that position, the shooting in the neighborhood would not have happened. That is our contention. That he did by waiting in the position of being the getaway driver and allowing the defendant to flee the scene, co-defendant to flee the scene. That he did intentionally aid and importune the commission of the criminal possession of the weapon in the second degree convictions. To the extent the acquittal on the robbery first, I submit to you that this is just a situation where a jury probably didn't want to attach the responsibility of actually committing the robbery to the getaway driver. And in some instance, this may have been just a compromise on the jury's part. But it's because we don't know what the jury was thinking, and these verdicts are not inherently inconsistent, is the reason why it should not affect the evaluation of the weight of the evidence. Absent any questions, I will rely on my brief.
Thank you, counsel. Case number 7, People versus Mateo. Justice Winslow is recused on this case. Counsel, welcome.
Good morning.
Please proceed.
Mr. Davison, I think you need to unmute.
Good morning, Your Honors. Mark Davison for Nelson Mateo Jr. I'd like to focus on 2 points in my argument today. The first is that Mr. Mateo's statement to the police was coerced by a threat. He, throughout this interrogation, he said he needed to attend his aunt's funeral, that he'd come up from Florida to attend.
Yeah, I don't see how that would be a threat when the officer said, well, I'll let the judge know about that.
Well, the threat, that you're right, Your Honor, that was not the threat, but the threat came when Mr. Mateo said, when Detective Colton said to Mr. Mateo, all right, I'm not going to tell the judge. You're not telling me what I want to hear. I'm not going to tell the judge. And it was only after that Mr. Mateo, who was desperate to attend this funeral, said, all right, and told the judge, told the Detective Colton.
So your argument is the withholding of assistance in attending the funeral, or the threat thereof, is coercion?
Yes, that's what I'm saying. Under that old U.S. Supreme Court case, Bram, that this court quoted in the Keene case, if a confession can never be received into evidence where the prisoner has been influenced by any threat or promise. This was, he had consistently said, I was there, but I wasn't involved in the shooting. And only when the detective said, fine, I'm not going to talk to the judge on your behalf, did he say, all right, I'll admit
Well, actually, the officer never said he would or would not talk to the judge on his behalf. All he said is he would make the judge aware of it. He never said he would recommend that he be allowed to go to the funeral.
That's at the beginning. That's what he said. I would recommend it, but then he I don't have the page in front of me from the record.
At some point, counsel, at some point, and I think your argument isn't just that, just that, you know, that he said that he would tell the judge. It's also, I think, in part, that the detective told the defendant that he had huge influence with the judge. So that, coupled with the fact that he was going to talk to the judge, you know, added to the coercive effect of this. Is that in part your argument?
Yes, he said, Detective Colton, this is at pages 457 to 460 of the record, where Detective Colton says, I'm going to end the statement. I'm going to go to the judge with and not put in a good word for you if you don't talk. And then at 461 to 464, Detective Colton reassures Mr. Mateo that his influence with the judge was huge. And it's only after that Mr. Mateo decides to change his story. And our argument is that this threat not to talk to the judge on behalf of Mr. Mateo is what tipped the scales. The other point I'd like to address is point 4 of the brief about the inconsistent verdict. Count 1, which is criminal possession of a weapon second, and count 4, criminal use of a firearm second, both require possession of a loaded weapon. And the jury convicted on count 3, but acquitted on count 4. And there's no way to reconcile this. The problem arose because what the judge did was he told the jury they could either use the CPW count or an assault count as the underlying felony for the criminal use of a firearm. If he hadn't done that, if he'd only used the assault, if he'd only told the jury they could use the assault as the underlying felony, the verdict wouldn't be repugnant. But because this court has to follow, has to review the crimes as charged to the jury, the verdict has to be inconsistent. With respect to the remaining points in the brief, I'll rely on the brief unless the court has any questions.
Very good. Thank you, counsel.
Good morning. May it please the court. Chris Eggleston in response.
Before you even start, I want to say something. Is this officer downplaying the Miranda warnings is disturbing.
I understand, Your Honor.
Go ahead.
I would just note regarding the issue that was argued that this promise to tell the judge that he had a funeral to go to just isn't the type of thing that I could find any case law to support a finding that it was either undermined his free will or created a substantial risk that he would falsely incriminate himself. There simply was no support in that. Typically, that's the kind of thing used when there's a threat to arrest a defendant or a third party, or the promise not to arrest a defendant or a third party. And my argument will simply be that this doesn't rise to that level. I take your point, Judge. Does
it matter in this instance that the defendant was in a highly charged emotional state?
Highly charged emotional state owing to the fact that he had that funeral to go to, Your Honor?
Yes.
I would submit, Your Honor, that, and I don't know this firsthand, but anytime that you're being interviewed about a shooting in a police department, it's got to be fairly highly charged. And I don't know if that particular quantum of emotion is the type of thing that changes the frame or the analytical framework. I submit that it does not, that the entire thing is fairly highly charged emotionally. But I would tell you, that, Your Honor, that in the end, doesn't this defendant himself say, I know it doesn't matter. I know I'm going to jail today. I mean, I think that that sort of tells it all as far as what his perspective was on that. And his perspective is something that we're called to address. Well, not we, but you all. So at any rate, moving on to the next issue briefed by counsel, or argued rather by counsel, there was a slight distinction. This was an argument by counsel that when I first read it, I thought I had a whole bunch of problems, and maybe I still do. You folks will tell me. But there is a distinction here in the instruction given by the court, and of course that's all we look at is the instruction. It's an interesting thing that we're looking in terms of the repugnant verdict or inconsistent verdict. We don't really look at the facts adduced and what might have led to the jury confusion, because for one simple reason, the jury is allowed to have the right to exercise their ability to acquit on some and not others, just for the sake of leniency. But at any rate, in terms of the inconsistent verdict, one read that it must be loaded and operable, and the other read that it must be loaded and readily capable of death. And that is enough of a distinction, I would submit. I would also submit, and while I know this isn't subject to a harmless error analysis, in the end, they got this right? I mean, we couldn't have, the conviction for the final count, the criminal use of the firearm, could never have stood in any regard. So had they convicted on that, the judge, had he known enough, and perhaps from his instruction, we might conclude that maybe he didn't, would have had to have dismissed that anyways. If there's nothing more, I'll rest on the papers. Thank you.
Counsel, thank you. Both counsel, before you sign off, and this is probably going to be helpful to future attorneys appearing on this. I know in the time of COVID, we're in a more somewhat informal environment, so I appreciate that. But as Mr. Davison noticed during his argument, he had not appeared with a jacket on. I thank you, Mr. Davison, for putting that coat on.
I apologize, Your Honor.
No, that's fine. Mr. Eagleson, we're not you folks, we're the court or justices of the court when you're referring to us during argument, and I appreciate that. Thank you.
Thank you, Judge.
Case number 8, People versus Myers.
Good morning, Your Honors.
Good morning, counsel. I believe your opponent has submitted, so please proceed.
Thank you, Judge. We have 4 points in our brief. I'd like to focus on 2 of them, the suppression issue and the issue with the transcript.
Well, counsel, let me just bring you to the first issue that poses, because this to me is the controlling issue on the suppression, whether we get to it or not.
Yes.
Quite frankly, is there's no dispute. Everybody agrees the missing and defective transcript. That's not an issue between yourself and the prosecutor, correct?
Right.
So really what we're faced with here today is the main issue that I see is the remedy.
Yes.
That's really the focal point, because it may and that may be what drives the ultimate determination here on what we do regarding any other issues you have. So why in mind, following the case law, that the remedy is summary reversal as opposed to reconstruction hearing?
Well, Judge, if I could, before I begin to talk about that particular remedy, I'd like to first note that the suppression issue, I think, stands on its own. That even if I didn't have this issue with the transcript, I think the court would still have to analyze whether or not the statement was voluntary and whether any new proceeding, for example, if there was going to be a new trial on its own as a result of the suppression issue, should go forward without the statement. So I'd just like to make that clear, that I think that is a standalone issue. But then
and there's no doubt the transcript is all present there, and
yes.
it doesn't have the same trimmings or problems that we have with the trial transcript. We recognize that.
Absolutely,
but in the past, depending on what our court procedure is, how we want to handle it, I really think it starts from analyzing the remedy because you're all right about this. I've never seen, nor hope that we ever see, a transcript like this again.
That's right, Judge. And getting directly to your question about the remedy, I think, a lot of things are going to be lost in any kind of a reconstruction hearing, which for the purposes of further appellate review will always and only just be a summary. And even if everyone gets this summary all right, and I have serious doubts about whether that can come forward to you and whether you can have confidence in that in the end, it will always be a summary. And I know that the court, when it reviews for weight of the evidence, it looks at the nuances of things. It looks at how questions are asked on cross, how they're responded to, and the devil is always in the details.
But the Court of Appeals has dealt with that issue, and they've dealt with issues where there's been missing transcripts and there's been summary testimony from the lawyers, testimony from the court recollection. And in this case, in my view, was a little unique, and I've never, because I couldn't find a case like it, where we had a subsequent or another trial of the co-defendant where the same witnesses testified in that trial, and their transcripts are available for review at a later date by counsel or anyone regarding the accuracy or problems or legality or legal issues that need to be raised.
I think you'd be taking a leap of faith if anyone did that, if it came back to this court after having a reconstruction on that issue. You would be taking a leap of faith that, again, that everyone had reviewed both transcripts. I think then you're talking about all the attorneys, the current judge, the former judge, reviewing both of the transcripts. I think you start to get into questions about economy at that point. But you would still be acting in faith on the concept that everyone had reviewed that other transcript, compared it to their memory of the transcript or the proceedings in Mr. Meyer's trial, and then came to some kind of agreement that it was either all exactly similar or that they came up with some listing, again, only in summary format, of things that might be different. And that is not a promotion of Mr. Meyer's right to weight of the evidence review with respect to his own case.
Well, counsel, the problem I have with your logic, okay, and it's a good argument. The problem I have with it is then any Court of Appeals case that was ever decided previously doesn't exist, because there's a weight of evidence in all the cases. Glass, Rivera, going on, and the most recent Huffler. I mean, there's a number of cases. So if that were to be true, that weight of the evidence could never be done, then game, set, match on the other case. They never would have decided the decision they decided because of weight of the evidence.
I think the breadth of the missing transcripts in this case and the requirement to here reconstruct the whole trial, because it's not just reconstructing these particular witnesses that are, completely absent or intentionally omitted.
Where I part ways with you is I don't disagree with some of your arguments. Where I have a problem understanding is they say, well, there's my understanding 36 witnesses testified.
Right.
There are 30 witnesses. I think we have their testimony, 6 that are missing. So the question becomes, is it one where you can make the weight of the evidence argument? Does it take 2 to be missing that you can't make it? Does it take 3 to be missing that you can't make it? I mean, those are the things. Like I said, I understand your argument, but if that were the case, Glass, Rivera relied upon the fact that prosecutor's memory was impaired because of a stroke. The lawyer was disbarred and couldn't be found. The judge was dead, and they went through steps of on those cases indicating they wouldn't need to do that. They just could have said it doesn't matter because the weight of the evidence can't be decided, and therefore it's a summary reversal. And they only reversed it based upon the lack of those people being present.
Right, Judge, and I understand that. I'd like to push back on 2 issues and then talk a little bit about how this court also can't review ineffectiveness in this context because of the particular cases. But first, Your Honor said that perhaps the court has to slice things up a bit to decide whether 6 missing witnesses is enough, or is it 3, or what have you. It's our position in this case that all of the witnesses are absent. You do have some nice, clean-looking transcripts for parts of the testimony, but none of it is certified. So it's our position that there is no official testimony in this case at all, and everything would have to be reconstructed. So I don't take the position that you're missing 6.
Are you arguing because of the breadth and that which is contained in the transcript that's present, that one can't even have confidence in any of the transcript?
It's our position that even if you look at the transcript and it looks clean, since it's not certified, you can't truly consider that to be a legal transcript that can be relied upon for appellate review. And if you ordered even if you ordered a reconstruction hearing, you would have to order reconstruction of everything because there is no official transcript. You can't parse out those ones that look okay because they haven't been certified. We can't go forward with that at all. I'd like to, if I could, talk a bit about how this also impacts ineffectiveness and what this court might be able to review in the future with respect to ineffectiveness if we had a reconstruction as opposed to just a whole new trial. I wouldn't necessarily expect the trial court judge to take note of all the objections that the defense attorney might have made or should have made under the circumstances. And I wouldn't necessarily expect the prosecutor's office to reveal that the defense attorney maybe didn't do such a good job or missed something and that, you know, it helps Mr. Myers on his appeal. In this particular case, we also can't rely on the defense attorneys to come forward with that as well, because this court's decision in People versus Shirk, I think, indicates to us that, you know, there's that sort of inherent conflict for attorneys revealing their own ineffectiveness. And then to make matters worse, in this particular case, the attorneys were actually accused of potentially committing a crime with respect to their representation of Mr. Myers and with respect to one of the core issues that would relate to ineffectiveness. I don't believe this court could truly have confidence in how that issue gets sorted out without having the ability to know that all of the players in that particular, if we're just talking about the expert issue here.
So are you arguing that the people who are going to be charged with the responsibility of reconstructing the transcript are also people who could be criticized, so you can't truly have that before the appellate court where the defendant could have the review that he is entitled to?
I think this court recognizes that reality in the Shirk decision. I think Shirk is just based on, you know, logic and human motives itself, that we know that people aren't really enthused about discussing how they might have, you know, failed in one respect, or definitely how they may have committed some criminal activity, which is precisely the position that the prosecutor took. So I don't believe you could ever, based on Shirk, based on the Fifth Amendment motivations of the attorneys, how the court could ever truly have faith.
The only difference this case is, compared to the Court of Appeals cases, the only wrinkle differently is that the defense attorney is now an assistant district attorney.
That further complicates.
And my problem is, and there's no disrespect, you take a blind leap of faith that because he's a prosecutor, his allegiance is more to his boss than it is to his client. We take an ethical oath as an attorney, and there's an obligation to a client, and I take that very seriously and very highly. And I'm not about to take the blind leap of faith that because he's an ADA now, he's going to shirk his ethical obligations and responsibility. I think that during the cross-examination of the direct examination and cross-examination of a witness, we can glean better on whether or not your theory is correct or not. But to blindly go in there and say that, I'm hard pressed to accept that.
Well, if I could respond to that, Judge, I'm not trying to impugn the attorney's character or make any assumptions about what he might do in the future. But I would like to take issue with the court's suggestion that it might be okay, or let me rephrase that. The defense attorney's sole loyalty should be to the client. And there shouldn't be the perception that perhaps there is also some duty of loyalty, which clearly the attorney also owes, to his own employer, or even to the client that he now normally represents in court, which is the people of the state of New York. It's not appropriate to have even the perception or the possibility that this singularly focused defense attorney could have these other loyalties as well.
So are you making this akin to an appearance of impropriety that would require, for instance, a judge to recuse in a case? That even the look of it is enough?
I think that Yes, I think that's a fair analogy. I think this court always has to be concerned with appearances of impropriety. Ultimately, you're going to have to rely on whatever transcript might come out of a reconstruction hearing for the purposes of weight of the evidence review or discussing whether or not Mr. Meyer's Sixth Amendment rights have been promoted. And since those are such weighty issues before the court, particularly with respect to the weight of the evidence review that's described as the linchpin of our constitutional system of justice in New York, I think it would be a mistake to leave anything on the table and to have a half measure when we could have the whole. And I would also note,
Mr. Abbott, you should wrap up now.
Okay, thank you, Judge. If I could just make one other comment. I would also note that having a reconstruction hearing is probably less economical than just having the whole new trial. It's less economical at the expense of the accuracy that we would always like to have out of these kinds of proceedings in a case where a person's going to spend life in prison. Everyone's going to have to review all the transcripts, maybe the Irene Myers transcript, and the man hours that will be spent by judges and court personnel and attorneys in accomplishing that goal would be numerous and would just kind of not be in favor of the ultimate goal, which I know this court's objective is just getting it right. So thank you. I'll rest on my brief for everything else, Judge.
Thank you, counsel.
Thank you, Judge.
Case 9, People versus Stackhouse. Also, welcome. Please proceed.
Good morning, Your Honors. May it please the court. During Mr. Stackhouse's interrogation, he was explicitly threatened that if he did not admit to the crime, he would be charged with murder and sentenced to lifetime imprisonment. This wasn't a threat that was implicit. It wasn't unclear. It doesn't require connecting any dots or making any interpretations. It was express. He was expressly told, if you exercise your right to silence or if you deny the crime, you're going to spend the rest of your life locked in a box half the size of this room. That threat was in the context of an entire interrogation where Mr. Stackhouse was told that police already knew what happened. They already knew that he stabbed Mr. Bryant, and that the only question...
Stackhouse being told as to possible charges and him helping himself. What's wrong with him considering what his actual reality was in determining whether he should or should not cooperate?
The case law is very clear that a defendant cannot be coerced into giving up his Fifth Amendment right to silence by being threatened that he'll lose his liberty. So here, I think what's wrong with it is that it's likely to induce a false confession where you tell someone, we already know you did this. That's a foregone conclusion. And if you admit that you did this accidentally, then you'll be treated better. So that's likely to get an innocent person to say,
I guess I allowed to use deception?
Police are allowed to use deception to a certain point until it becomes just fundamentally unfair. The deception in this case did reach a point of fundamental unfairness because he was told that 3 people implicated him in the crime who did not. Unfortunately, due to defense counsel's ineffectiveness, a lot of that is not fleshed out on the suppression hearing record. So that's why we're really focusing on the threat portion of this. The threat and the corresponding promise is really what's the problem here. And it continues, the thread really continues throughout the entire interrogation where, when he denies the crime, he's told, no, you're lying. That's a concocted story. We know that you did it. And they're
saying that the defendant cannot be confronted with inconsistencies based upon the investigation of the police?
He certainly can, Your Honor. It's just that they took it too far here when they threatened him. That sort of, you will be treated differently depending on whether you admit to this crime or not. That's where the line is. It's when they start bringing the criminal consequences into it, is where they cross the line. that threat that I highlighted happened in the middle of the interrogation. Towards the end, they said, "This is a matter of whether you will be judged as a truthful person or someone who's really bad, a cold-blooded murderer." So he's being told, if you don't admit to this and tell us it was an accident, you're going to be treated as a murderer in the criminal justice system. And we've already told you that means lifetime imprisonment. And that's where the line is. The police cannot threaten a defendant.
Let's assume we don't buy the argument. Why don't you address for me the lack of or thereof cooperation regarding the two separate robberies? That appears to be when you get to your weight of the evidence, when you talk about the robberies that took place, the robbery of the wallet and then alleged robbery of the $10.
Correct. So the people's theory was always that this all happened at one time, that Tony Comer stole Marvin Bryant's wallet, that Shakeith was an accomplice to that, and that Bryant was stabbed and killed during that robbery. There was insufficient evidence that happened, that Bryant was stabbed during that robbery, or that Shakeith even participated in that robbery. The defense theory, and what I think makes far more sense based on the evidence, is that there was actually two separate incidents that were separated in time by about 10 to 15 minutes. First, Tony Comer alone steals his wallet. He rips off the white t-shirt. He's dragging him on the ground. The whole thing with the white t-shirt happens. Marvin Bryant leaves, returns, and then there's a second incident in which he's stabbed. I would urge that even to the extent that it's equally possible that it could have happened at one time or it could have happened as two different incidents, it was obviously the prosecutor's burden to prove it one way or another, and they didn't. So Tony Comer's robbery of the wallet cannot be the underlying felony for felony murder. I'd like to point out that that was the theory that was presented to the jury. So the only theory that the jury was presented with was Shakeith Stackhouse participated in Tony Comer's robbery of the wallet. It all happened at once. So now we have this question of a possible second robbery, and respondent says, in the alternative, this court can find that that was the underlying felony. I think they are actually restricted to their theory at trial, because that would be an entirely different underlying crime for the felony murder. So I think either they proved that Shakeith Stackhouse participated in Tony Comer's robbery, or they didn't prove it. And they didn't prove it, and that requires reversal based on insufficient evidence.
What about counsel? What about his asking to change an attorney? He had a conflict with his first lawyer, a lack of communication, seeing eye to eye.
Correct. Twice his complaints about counsel were essentially ignored. He made serious and specific complaints in a letter that for some reason wasn't addressed for 5 months, and then the court simply said, no, I'm not going to give you new counsel. He then made a motion.
Any inquiry after that 5 months into the specifics of the concerns of the defendant?
There was not, Your Honor. The court simply said, I can't remember the exact words, but it was something along the lines of, this is a good attorney, I'm not giving you another one, he's working hard on your behalf. And Mr. Stackhouse specifically said, we're not seeing eye to eye, and the court didn't engage in any inquiry. The court had a second opportunity to engage in some inquiry when Mr. Stackhouse filed a motion, again with specific complaints, and again in March, he said, the court just said no. The respondent is urging.
What about the court's concern or indication of there's a trial date and focusing on the trial date above arguably all?
That, Your Honor, that was inappropriate. Of course, the court should have been concerned that this case had been pending for a very long time, but that concern can't take precedence over the defendant's right to counsel.
Oh, counsel, not only that, but we have a lot of cases where the defendant is making the claim of not being able to get information from the lawyer, they're not communicating well, and it's usually done like a week before the trial is scheduled. This particular case, we've got many months that preceded the trial, where there's a letter written, a motion made. I mean, there's a lot going on here, and it's not your typical eve of trial, nervous, I want a new lawyer situation, correct?
Correct. And I can't imagine how frustrating it would have been to Mr. Stackhouse that he asked for an attorney so far in advance. And then when he finally did get one, it was an attorney who only had 10 days to prepare, whereas she could have had months and months if the court had just taken this seriously earlier. And while it is not relevant to the sides issue, it's worth noting that she really was unprepared for trial. Her theories were confusing. She didn't present a clear and coherent theory to the jury. You know, she failed to do various things. And so she didn't actually provide him with effective assistance of counsel, which was probably because
to consider how it was that she was allowed to become his new attorney. In other words, that she had to agree to proceed with the trial date. The defendant had to understand no delays for the trial.
I think it is important that it was essentially a conditional grant of a new attorney, that the court said, fine, you can have a new attorney, but she had to agree to the judge on the record, I will not ask for an adjournment. So she had to essentially tie her own hands in order to take the case. And if she started looking at the papers and said, I need more time to get an expert, I need more time to talk to witnesses, she was told she could not request an adjournment. And that's an inappropriate condition to put on a grant of a new counsel.
Anything further, counsel?
That's it. Thank you very much.
Thank you, counsel. Counsel, proceed.
Good morning, Your Honors. Ken Tyler for the people. I will just try to address briefly each of the questions raised here at oral argument, and then I'll rely on our brief. First, with respect to the voluntariness of the statement, the record speaks for itself. I'm not sure I agree with the characterization. If you deny the crimes, you will spend the rest of your life in prison. I'm not sure that's really a fair summary of the full context, the totality of the interrogation, but I think that record speaks for itself. Just with respect to the theory, I think the jury was not required to accept the timeline proffered by defendant. This is obviously a transaction that occurred over the course of several minutes. Multiple people were involved. Obviously, the wallet was taken at one point. I think each of the cohorts agreed on
a 15-minute break or some amount of time of a break between the initial taking of the wallet and then the murder itself?
I'm not sure. Well, here's the timeline as I understand it from the trial transcript, and I'm fully appreciate the panel is very familiar with the record in every case it hears. But from what I gleaned from the record, at 7:39, the victim crosses South Salani Street, heading toward this transaction in his sweatsuit. 2 to 3 minutes later, the defendants are seen meeting up across the street. By 7:50, defendant and his cohorts were recorded walking by Black's liquor store. So at that point, the encounter had already occurred. The victim at that point, simultaneously to that, is walking home, heavily labored breathing. He had already been stabbed by that point. So I'm not sure there's a 15-minute completely separate break from.
But when his wallet was taken, was not his shirt ripped, and then he shows up with a sweatshirt?
The trial transcript suggested that he was confronted by Tony Comer during some off to the side encounter, and it sounds like Comer did take the wallet, pulled his shirt off in the interim, walked back to the group with a smile on his face and the wallet. But then it's entirely, the jury could have easily accepted, and I submit to you it's perfectly reasonable that the victim slipped back on his sweatshirt, even if he didn't have the white t-shirt, because Comer was holding it and laughing. And
so does the prosecution's view that it's all just one transaction, no break?
I mean, I think the facts support that conclusion. I don't think there's a basis to reverse based upon that conclusion. And then just following up, the way that the transaction continued was defendants' cohorts verbalized their knowledge or their belief that the victim still had cash on him and they wanted that cash. Defendant admittedly re-engaged in a melee, even if he personally wasn't interested in the cash. He re-engaged in the melee. He admitted that he had a knife secreted in his sleeve. And it was during that part of the melee that the victim was stabbed with the knife. On that basis, on that narrative, I submit to you that the verdict was, the judgment was supported by legally sufficient evidence. With respect to the counsel issue, I'm as troubled by the record that was made as you are as defendant. Is there needs to be an actual substantive inquiry, not simply making the paramount concern the trial date. All I could really offer you is, what the record supports, and that's that defense counsel didn't verbalize any problem preparing within 10 days. There are cases out there with shorter preparation times. The record,
Counsel, I guess what tees this up a little bit different than some of those cases is the fact that there's been prior requests with problems with counsel months and months earlier. And it's clear from the record, there's really no minimal inquiry being made on either of those requests. And I think that's teed up with the fact of, this is not going to change the date, trial date's not going to change. So the choice you're faced with, either accept who you're taking now with no adjournment, or I'm not going to grant it. I mean, that's what you can read in between it. And that's what gives rise to the troubling aspect here of, and all it calls for is a minimal inquiry.
I share your concern in explaining action or inaction on complaints about counsel, or sometimes those are the hardest actions or circumstances to explain or defend on appeal. It's troubling. Well, all I could point to is the fact the court ultimately did give him his new attorney. I'm not sure that renders the earlier substitution problem academic. That's my position. It may go to ineffectiveness and whether you believe counsel lacked time to provide effective assistance in that 10-day window, but she didn't request any further adjournment. I recognize that the court spoke somewhat strictly about having assigned the attorney in that short time frame. I fully recognize that. She didn't ask for any further adjournment. It's just purely on this record, in my mind, whether you view counsel's efforts. Maybe that plays into the ineffective assistance argument, and I agree it's a concern.
I think we have that argument, counsel. Thank you.
Thank you very much.
Case 10, People versus Wright. Counsel, welcome.
Thank you, Your Honor.
Please proceed.
May it please the court, Caitlin Connolly for Appellant Kirkland Wright. When everything started in this case, Mr. Wright was merely walking down the street with another man who was holding a tall can in a bag. On these facts, County Court incorrectly held that the three officers had grounds to approach the two men, due in part to the fact that one man was in violation of the open container law. Notably, there was no testimony at the suppression hearing that the officers had observed the men drinking from the can as they walked. As such, the people's reliance on this court's decision in People v. Mack is misplaced. Unlike Mack, where the officers had a founded suspicion of criminality because the men were drinking from the large bottle in a paper bag, there was no evidence in this case, again, of drinking.
But Counselor, you take, I think, a leap when you go to criminality. I guess we look at credible reason to approach. Well, two men walking down the street, open container, reason to approach and inquire about the open container with the individual with the open container. So I think we have therefore a reason to approach. Next question is really the defendant's conduct. Does defendant's conduct walking away, blading his body, reaching for his waistband, giving a non-plausible date of birth when questioned, whether or not that gives rise to another level to a DeBoer level 2 or 3.
I'd also point out, Your Honor, that there was no testimony in this record that this was a high crime area or that a crime had been reported. So all the officers had this concern to start, as you mentioned, was the open container. They were just going to investigate the open container. The officer testified that my client bladed his body.
Counsel, didn't the defense attorney during the cross-examination of the police officer in a question state that they were on a patrol as part of that special unit that they were in, which was supposed to patrol such areas?
Your Honor, I don't recall that I think my recollection of the record is that the officer said they just were on this general crime patrol. I don't recall that there was any testimony on this record that this was a high crime area. As to the alleged blading, my client's alleged blading of his body, I prefer the term move sideways or angled his body. And very near touched his waistband. The record confirms that, but it was there was no other evidence of a gun or a bulge or whatnot. He just simply touched his waistband, and the Court of Appeals in Robbins has held that the touching of the waistband alone is not indicative of criminal activity. As to the alleged false
argument here, it's.
I can just ask you this, counsel, and I'm looking at the divorce step one still. You know, in other words, if it's the container, is your argument that if it's the container that is allowing them to approach, is it approach the person with the container only, and then your defendant, your client has moved off to the side, and there's no step one reason to approach your client?
My argument is that there was no step one approach to the officers weren't entitled to approach either men, Your Honor, because there was no indication on this record that the container was open. You know, it's not against the law to hold a tall can in a bag. If you look at the case law, Your Honor, where it has been an open container law has been found to be a predicate for a police-citizen encounter, there's nearly always drinking, some level of drinking, observation of drinking. These men were just walking. They weren't loitering. They were walking down the street. So my argument is that they shouldn't have approached either man, and certainly not my client, especially after my client pulled aside so that the police could investigate the man who was actually holding the container. As to the allegedly false answers that my client gave, they did not indicate that he was dangerous, and they certainly did not justify the officer's rapid escalation of the encounter by forcibly grabbing my client's clothes and putting his arms on his head. And the record also shows that the officer had a mistaken belief that my client was another man for whom there was an arrest, or for whom he claimed there was an arrest warrant. But the people never proved at trial the reasonableness of this mistake of fact. And it seems improper that an officer could simply say that I searched this man because I thought he looked like someone else, without exploring the reasonableness of that belief.
Anything further, counsel?
No, Your Honor. Thank you.
Thank you. Counsel, please proceed.
Good morning, Your Honors. Darian Balin on behalf of the people. I would like to first address one of the questions that Justice Centro raised. Our position is that there was a level 1 objective, credible reason to approach. They observed, and the officer testified that this observation was based upon his experience as a police officer, that the bag with the can could have contained an open container of alcohol. They approached Mr. Smith, and it wasn't simply defendant's actions.
Let me ask you this. So if somebody's walking down the street with something in a bag, and there's no evidence that they're drinking out of it, there's no evidence that it's an actual open container, it's a bottle with a top off of it, for example. It's just something in a bag. Is that based upon police experience enough to know or to believe that that might be an open container and it may have alcohol, so therefore they can approach and it justifies a level 1 DeBoer?
I think in this specific case, it is when the officers, as Justice Winslow pointed out, were part of a specialized response unit. The time of night, the entire circumstances here would have given rise to that reason. But even
Counselor, didn't the officer testify that it was a tall can inside of a paper bag, and that in his experience that was the kind of container that they find with alcoholic beverages?
Yes, Your Honor, he did.
Was there any testimony whatsoever that it was open or they were drinking out of it?
No, Your Honor, there was not any testimony regarding anyone drinking out of the bag.
Counselor, in addition, at the point in time that the defendant had moved into the driveway, was blading his body and reaching to his waist with his hand and on the side of his body that the officers couldn't see, hidden from their view. They hadn't even asked a question of the individual carrying the can in the bag. They'd simply told him what they were, why they were coming towards him, but they hadn't even started to inquire, had they?
Exactly, Your Honor. And this was the point I was getting to next. It wasn't simply defendants moving aside into a driveway to allow the police to talk with this other man. That could have been an innocuous action, but it was the moving aside with the blading and guarding his body away from police view and touching an area that the officers couldn't view, that all combined.
If I could, your opponent describes the blading as turning sideways. What's the difference between turning sideways and blading?
I don't think there's much of a difference. I think blading is a police.
Blading is a term of art that we've come to know from police officers who testify that blading, because somebody turns sideways, they suspect that somebody's hiding something on the side that you can't see, right? So the term blading is supposed to communicate that the officer feels that they may be at risk, right? That there may be a weapon, there may be something that this person's hiding. But was there anything other than the turn sideways that would have indicated this, that there was actually a weapon involved?
Correct, Your Honor. I think blading is a police term of art that they use to describe this specific type of movement. In addition to the blading movement, there was the touching at the waistband, which, when all things were combined together, and you then get to the officer's approach and asking for defendant's pedigree information, and the officer testified that he had stuttered speech, appeared nervous.
Counsel, would you agree that once the defendant moved into the driveway area and the officer approached him, that things escalated pretty quickly after that?
They did, Your Honor. They certainly escalated quickly, but we submit in our brief that they escalated quickly because of defendant's actions. He gave these nonsensical answers to the officer's general pedigree question that piqued the officer's suspicion even further. Then, when the officer requested that he place his hands on top of his head, defendant continued to remove them and touch that same waistband area that he had been touching previously. So while the encounter escalated quickly, it was because of defendant's actions. Okay. And we would submit, for all those reasons, the county court's suppression decision was proper. Okay. Thank you, Your Honor.
Thank you. Cases 11, 12, and 13.
Judge Smith will work on getting Judge Whalen back.
Hey, Emma.
No comment.
Judge Whalen, you're muted.
Now you're frozen.
Good luck.
No, I think I'm okay now. Am I? Yep.
Fine. Loud and clear.
Very good. Thank you. Very good. I believe we have everybody present. Yes, we do. Counsel, proceed.
Muted.
Oh, you're muted.
Mr. Davison.
Thank you, Your Honor. Mark Davison for Appellant Cala B. This case has been before the court twice before, and the court has held that a preponderance of the evidence supported the DSS determination that the children were neglected as a result of Calla B's mental illness. Now we've come to the point where DSS is asking the court to find permanent neglect and terminate her relationship with her son. And that requires clear and convincing evidence. I submit that there is no such clear and convincing evidence. There's never been a diagnosis in the record of any mental illness on the part of Calla B. There's no indication that she's been prescribed medication that she's not taking, that she's failed to engage in treatment that doctors have ordered for her. We're at the point now where she's about to lose her relationship with her son, and I submit that a stronger showing has to be required than it has been in the past. If this petition had been brought under Section 384B4C of the Social Services Law, based on mental illness, family court would have had to order an examination.
Counsel, let's cut to the chase. The court really focused mainly on her failure to cooperate. I mean, it's throughout the record, her lack of failure to cooperate. That's apparent in the record. And you had Williams, and the court credited Williams' testimony. And you seem to be holding your head on the fact that if it's mental health, then what they should have done is approach it a different way. However, as you know, we've got prior decisions in this court dealing with her mental health, correct?
Correct. And
the court was aware of those.
Pardon? It
was the same judge.
Yes.
No, go on. Never mind.
I'm sorry. Actually, I'm not sure it was the same judge. I think it may have been Judge Doran at first, and then Judge Reed later on. But I would with respect to the allegation that she's or the finding that she hasn't been cooperative, she's been trying to maintain contact with her son. She's the one who has consistently suggested agencies that can supervise visitation. She has said that she's willing to have the case supervised by DSS itself, by DSS in Monroe County, and none of these options have been offered to her. Instead, the burden has been put on her, which it never should have been. And
part of the problem. Go ahead, Justice Chavez.
What about a simple fact is providing information as to where she physically lived, so the home could be checked out?
She has refused to do so, but I would point out that the address became apparent during the course of the proceeding when her son Thomas filed a petition, and he was living with her, and he gave that address, and it didn't make any difference. There was
really, is that what the family court has to do? They have to hope that the address can be found in another document somewhere in the file because the mother won't provide something as simple as here's the address so that somebody can go to the house to inspect it to see the conditions of the house. I mean, that seems to be a very basic item to expect of somebody in terms of cooperation so that the department can do their job.
I agree, Your Honor, and I believe that but if the problem is in fact a mental health issue, and this is what is at the root of the failure to cooperate, then the court should be aware of what her condition is before it terminates the right to see her son.
Well, what about the fact that she wouldn't even cooperate with respect to providing information as to her mental health?
Well, her position is that she did so. She went to see her own.
No, she wouldn't provide any of the information concerning that.
She provided the report from Dr. Reinhardt.
Counsel, did she sign releases?
She did at one point in the proceedings, and then later on she refused to do so.
Counsel, my understanding is incorrect. I could be wrong, but her evaluation with Dr. Reinhardt predated this court order. And the court order said, like, you to get a mental health evaluation, says I already have one, and the court had ordered a subsequent one. Really, that's what we had before us. Isn't that correct?
The Dr. Reinhardt report that was from years before.
It was during the pendency of these proceedings. It predated the order appealed from, certainly. But her position is that she has provided Dr. Reinhardt's report that DSS refuses to accept it, and the court has.
Also, is the argument that your client gets to determine what reports relative to her mental illness that the court gets to see, and if the court wants something else, the client decides whether the court's entitled to get it in terms of doing your evaluation? Is that the argument?
My argument at this point is that if she's got a mental health problem, the court should be ordering her to get an evaluation, which it has the authority to do had the petition been brought under Section 384B4.
But it wasn't brought under that section.
But it was not. No.
Okay, I think we have your argument, counsel. Thank you.
Thank you, Your Honor.
Counsel?
Thank you, Your Honor. May it please the court, Holly Adams on behalf of the Ontario County Department of Social Services. Unless the court has any specific questions, I'll address the arguments set forth by counsel today. No, we did not bring it under that specific section. I would point out the court did order on multiple occasions that appellants submit to psychological evaluations, and she refused to do so. The most recent being under the order of disposition. The same order of disposition she was ordered to adhere to twice. She never cooperated with that order, so what makes anyone think she would cooperate with any further court order in this situation? That would have been a futile effort. This case has languished long enough. The department has continued to run into brick wall after brick wall with this woman. I would concentrate on the progress that we did make in this case, and that is with the child. I think it's clear from the record, clear from the brief and the testimony of Dr. Hahn and Christine Williams, the evolution of this child into a flourishing, happy 13-year-old. And that's what I want to concentrate on here. His mother fought not for his return, in my opinion. His mother fought to fight the department because of her hate, her complete disdain for this department.
Thank you, counsel.
Thank you.
Case 1415, in the matter of Adam Henshaw versus Caroline Hildebrand.
Good morning, Your Honors.
Counsel, good morning. Welcome. It looks like your opponent is submitted, so please proceed.
May it please the court. Regarding point 2 of my brief, the enforcement petition, family court did not follow the proper procedure for determining that New York was an inconvenient forum as outlined in Domestic Relations Law Section 76F. First, family court failed to give the father's attorney a sufficient opportunity to respond to the mother's oral motion to dismiss pursuant to subsection 2 of that statute. Second, family court never considered the factors in subsection 2, A through H, before concluding that New York was an inconvenient forum. And third, family court erred in dismissing the enforcement petition outright on the ground that Texas was the more appropriate forum because subsection 3 requires that the proceeding in New York be stayed. With respect to point 1, the family offense petition, contrary to the contention in the mother's motion to dismiss, family offense petitions do not need to be verified. Family Court Act Section 821 outlines the requirements of family offense petitions and
I understand that, Ms. Waldman. There is no requirement that it be verified.
Thank you. Family Court also had personal jurisdiction over the mother pursuant to Family Court Act Section 154, which she conceded when she averred that she received a copy of the petition in the mail. And the father was able to show a cause of action for at least harassment in the second degree based on 110 instances of unwanted communication over a 2-day period. Therefore, Family Court erred in dismissing the family offense petition. In conclusion, we ask that the court reverse Family Court's orders, reinstate both petitions, and remit these matters to Family Court. Unless there are any questions, I will rest on my brief.
No questions, counsel. Thank you.
Thank you.
Case 16, NYAC versus Wells Fargo Bank. Counsel, you're a little sideways.
Sorry, Ron.
That's all right. This is pretty nice.
It's a different way of looking at the case, huh?
Yeah, pretty quickly. Very good. Counsel, please proceed.
Good morning. And may it please this court, my name is Mark Blanchard. I'm an attorney appearing today on behalf of the plaintiff appellant in this matter. This appeal is brought to this court to overturn the lower court's decision on a discovery matter. The history of this case is quite long.
Counselor, unfortunately or fortunately, we're familiar with the history and
yes, sir.
Firsthand. But
yes,
here's the way I look at the court's decision. You can correct me. I'm trying to. I find this issue very narrow.
Yes, sir.
It's enforced today. The court ultimately granted the quash the subpoena regarding Canellis, basically saying without prejudice, the plaintiff can move to narrow the scope of the documents and non-privileged and related materials. So the issue comes down, in my view, is whether or not Canellis may claim attorney-client and or attorney-work product privilege. And your argument seems to be that the crime fraud exception is really what precludes him.
That's correct, Your Honor.
Because it seems to me that's the very narrow issue before us.
I agree, Your Honor, this is a narrow issue, and I think that you have stated it perfectly. I think that based on the lower court's decision, the lower court recognizes this court's prior decision from 2014 that recognized fraudulent activity.
There's no, and I can assure you it wasn't dicta, okay? But with that being said, that decision was really focused more on the Wells Fargo and Roach PC.
Yes, Your Honor, but what I think is also an issue here is that the lower court recognizes that there are emails and correspondence where Canellis, with Attorney Canellis, was clearly a part of the events that led to this stinging rebuke from this court in 2014. So we feel that that Canellis is not shielded, that he has forfeited the protection of the attorney-client.
Well, let me ask you this question, and
yes.
I looked at it. I read the opinion. We have a situation here where I don't see anything where he was involved in the underlying foreclosure. He didn't appear of record on the underlying foreclosure. He didn't draft the underlying non-proton motion to the court, nor did he appear on that behalf. Now, am I wrong in any of those assumptions that I'm making?
No, you're not, Your Honor, but it's within that description that I think we find the potential for very egregious conduct. It could be that under the assumption, based on the 2014, that there was a scheme afoot, It could have been that intentionally Kanellis stood by the sideline. The lower court recognized that he was monitoring all of those actions you just described, but he did not make or file a notice of appearance. That's indisputable. But in my mind, what we're afraid of here is that that was an intentional omission of filing of a notice of appearance to take advantage of this very situation. And to me, that is an egregious perpetration of the fraudulent conduct.
Fair argument. Fair enough.
Anything further, counsel?
Your Honor, I would like to add that in terms of the overly broad argument, the plaintiff appellant limited the subpoena to Kanellis' records as it relates to the property. There really was no other way. Our argument respectfully submitted that there's no other way what could have been more narrow in terms of the breadth of the subpoena. That's the only thing else that I would like to say, and that if there are no further questions from the court, I would rely on submission.
Thank you, counsel.
Thank you.
Counsel, proceed.
Good morning, Your Honors. Steve Lazar for respondents, Wells Fargo and Aquin Loan Servicing. Your Honors, to begin, there's numerous procedural defects with the subpoena and the notice of deposition over here.
Well, we recognize the defects you raised, but assuming that we get past those, because lack of prejudice and some other factors, assuming we get past them, your argument is the court the court's decision was correct. Because the court found that our prior decision didn't encompass the crime fraud exception regarding Kanellis.
Right. So, Your Honor, the trial court's decision over here was correct in finding that the document demand was extremely overly broad. It asked for an attorney's entire file on a matter. Yes, it was, it said with respect to the property at issue over here, but that's the extent of how it was, I guess, narrowly tailored. But it wasn't actually narrowly tailored, as the trial court found here. And the court said that it was quashing her document demand with leave to renew without prejudice. So over here, the plaintiff has not made any showing that the Shapiro law firm or Mr. Kanellis had any involvement in the underlying foreclosure action.
Well, his argument appears to be, and I think it's not unreasonable, it appears to be that he was on a peripheral edge. He was there the whole time. He was kind of like the quarterback overseeing or watching what's going on and had some involvement whatsoever, even though his fingerprints don't appear to be on it with reference to an appearance of record.
No, Your Honor, I respectfully disagree on that point because there's an email over here in the record explicitly stating that Mr. Kanellis is just handling the REO transaction after the foreclosure case, after the first foreclosure judgment was issued. He had no actual involvement in the underlying case. He never filed an appearance. He never prepared any documents over there. There's nothing in the record to indicate that he had anything to do with the foreclosure action other than monitoring it. So yes, if he's monitoring it, yes, he's going to have, peripheral, I guess, appearance in that case, but he never actually appeared in that case, and he had no involvement. That's the key point. And under, Fourth Department case law, in order to have the crime fraud exception apply, you have to show that the attorney was actually involved in the underlying litigation. There's a two-pronged test over here that is court laid out, and you need to show that the attorney's involvement, the documents that are being sought, were actually used to commit that fraud or, misconduct. Over here, there has been no showing like that because there was no involvement by Mr. Kanellis. If the court has
anything further, counsel?
Nothing further. Thank you.
Counsel? Mr. Manella?
Oh, good morning, Your Honor. I thought Mr. Kanellis' counsel was going.
what I'd like to point out is the term of art here at issue is fraudulent scheme. And even taking this court's prior decision referencing at worst the fraud in the nunc-pro-tunc motion, here we have an action that begins with the foreclosure several years before that. And what the appellant is relying on is a fraud, but the issue is a fraudulent scheme. And nowhere in any decision by the lower court or in this court's prior determination was there a reference to a fraudulent scheme. And I think that the lower court was correct in finding that the witnesses' involvement was on the periphery and just checking for status. And the privilege log that was provided to the lower court demonstrated that. And there was nothing in that privilege log that led the lower court to believe that Mr. Canellis' involvement was more than that. I think, as the appellant brought up earlier, that Mr. Canellis actually intentionally made the determination or made any weighing that I should not file a notice of appearance here, because if I do, it will show that I am involved, and waiting, the word used was a quarterback. Mr. Canellis was communicating with the Roach firm to follow for a status. The Roach firm was the one that had brought the nunc-pro-tunc. So Mr. Canellis was not giving advice to the Roach firm. The attorney-client privilege did not go between Canellis and Roach. It went from Canellis to Wells Fargo, and the other privilege went from Roach to Wells Fargo. So to the extent that Canellis and Roach were communicating, that was just to provide Canellis with the status. In the fraud crime situations that were brought to the court in the briefings, that typically involves the fraudulent scheme where the attorney is advising the client how to commit a crime, how to conceal a crime. There's nothing of that here, Your Honor, and it wasn't demonstrated by the appellant.
I think we have that argument, counsel. Thank you.
Thank you.
Thank you, counsel. Case 17. In the matter of Nino H.
Have to unmute, start video. Hold on.
Okay, sorry about that, counsel. Are we ready to proceed? We got 1, 2, 3. Very good. Counsel, proceed.
Mr. Bellatir, you're on mute. Okay.
Good morning, Your Honors. Anthony Bellatir for the appellant Danielle H. Sorry about this one. This is a case of derivative neglect. I'm aware that this court is familiar with this family from prior cases. However, I submit that an individualized assessment of the evidence regarding the child Nino H, that the petition was not sustained. That's really the only point in my brief. I did break it down into 3 subsections, which is regarding the various elements of the so-called derivative neglect doctrine. So the first one that I cited was the requirement that the original allegations of the prior adjudication should reflect a fundamental defect in the parent's understanding of the obligations of parenthood. And the reason I don't believe that applies is because Danielle F has always said from the outset that she knows that she has intellectual disability and mental health issues, and that she knows she needs help and she's asked for that help, and she's always
Are
cooperated
you
with it.
suggesting that that help wasn't provided for her and her husband in order to address the issues that caused the removal of the other children?
I do think in some ways that it was not, Your Honor, and let me, for an example, let me talk about for a minute about this issue of the so-called unpleasant odor that was in the house. This is something that's been alleged again and again and again since 2011. And at no point did the county simply go to the house and say, let us help these people identify the source of this odor and try to remedy it. And there's evidence that the Daniel F. Tried to clean the house and scrub it with bleach and everything. And they just kept saying, well, we still smell this odor. Let me also say that, but in regard to that, there was no evidence that the odor was actually harmful or a danger or anything. And this sort of, I think, indicates that there came a point where...
So you're suggesting that despite the manner in which this odor is described, it is not indicative of a less than sanitary home?
I'm indicating that there was no proof that the odor, if it did in fact exist, represented a imminent risk of harm, and that's what the standard is. Was it unpleasant? Maybe. I don't know, but that's not the issue.
The house wasn't properly kept and proper sanitary conditions kept. You're saying that's not a possible harm to the child?
It may be in some ways. Is there rotting food? Is there vermin? I don't know, but an odor, unidentified odor that the department never remedy.
There was more than an odor here. There's a concern that there was a lack of progress, even with the services that were provided.
Yes, Your Honor. Let me speak to that too. A lot of the allegations concerning the parents not making progress in service are actually subjective, vague. My client particularly was diligent in attending the services, cooperating with the services. She never said, I refuse, I'm not doing that, I don't need that, nothing of that kind. In fact, she always said, I will cooperate and I'll even do additional things. And
wasn't she advised to complete the domestic violence class a second time, yet she never did that?
I think that she did complete it one time, and I think that she was still in progress of doing it again. Although that's another example, Your Honor, where she took the classes, she participated, and then the argument was made, well, she hasn't made enough progress. It's subjective, it's self-serving, and
well, Counsel, when it comes to these services and the mother or the father going to these classes and the determination as to whether or not they've completed them, there's going to be an amount of subjectiveness to that, isn't there always?
Is there amount of, I suppose, Your Honor, I would concede that, but there's still the bottom line is there imminent risk to this child? And has that been?
There was also the objective fact that the parties continued to reside together after domestic violence.
Well, the only proven incident of domestic violence was years before the fact-finding hearing, 2 years before the fact-finding hearing. And furthermore, even that case of domestic violence, the children were not present at that time. And I've cited case law that says that the children are not present. It's not a case of child neglect. There's no indication that they ever committed domestic violence with children there. So no, I don't think that domestic violence constituted an imminent risk to Nino H. either. I've also pointed out that many of the allegations are very old, dating back to 2011, and they keep being recycled and re-alleged. And at some point, I'm suggesting they
Counsel,
become too remote.
you agree the focus is supposed to be whether or not they address the issues that led to the removal of the other children, correct?
I do agree, and I also think that they did demonstrate, or at least my client did demonstrate, that she had ameliorated those issues by attending parenting classes, by attending domestic violence counseling, by cooperating with a mental health treatment plan, by having OPWDD services in the home, which would have been there to monitor the situation with this child. And I think she did remedy the conditions, and she did adequately demonstrate that there was no imminent risk of harm to Nino H., Your Honor.
Anything further, counsel?
Nothing further, Your Honor, unless you have any other questions, I'll stand on my brief.
Very good. Thank you. Counsel?
Thank you.
Counsel Sekila?
Oh, I'm sorry, Your Honor. Maggie Cycli for the Onondaga County Department of Children and Family Services. I respectfully submit, Your Honors, that the proof presented at the fact finding did show that the parents of Nino H. did not ameliorate the conditions that led to the neglect and permanent neglect of Nino's 5 older siblings by failing for a number of years.
Also, how do you answer the question that your opponent has raised that there seemed to be this ongoing complaint about this odor, an odor that was strong enough to bring, to water people's eyes as they moved into the living space? How do you counter the argument that, wait a minute, you can't just say, yeah, there's a strong odor, fix it, and when the client tries to fix it and they think they do, but they don't. They got rid of some dogs here, right? I mean, they took some steps. They weren't completely just saying, I bought a bottle of bleach, period, that's my job, I'm done. It did seem to be like they were taking some steps here. How do you answer the question is why didn't the department do more in terms of trying to isolate what is causing this and giving some instruction on how they could fix that problem? I mean, that was only one of the problems, but it was one of the problems that's been highlighted in the papers.
Yes, Your Honor, and I think the department's position is that if it's their responsibility to maintain a clean home, not the department's responsibility to clean their home for them, which I believe is what Mr. Bellatier was suggesting. And as Your Honor indicated, that was just one problem. In fact, my understanding is that the department started.
Counsel, would it be different? I don't know that he's arguing that the department needed to go in and clean the living space, but rather I think his argument is they needed to help at least identify where the odor was coming from, help identify, or make suggestions as to how they could help identify the cleaning space. I mean, not go in and put rubber gloves on. Nobody's suggesting that, I don't think.
Yes. I think there were concerns. Essentially, we knew where the odor was coming from. In previous cases where this court has ruled, there was a cat spraying in one of the bedrooms. And so there was never a question about where this odor was coming from. It was clearly coming from animals that were being kept in the home. And again,
so the argument could be that there was an addressing of that problem by getting rid of a couple of the dogs, but after that they needed to do more and they didn't do more.
Yes, Your Honor. And also they did have, mother had access to OPWDD services, which she did not fully take advantage of, that would have provided her with in-home services that would have assisted her in cleaning the home for the child. So
what about the claim that mother participated in the services that she was required to do so as it related to domestic violence?
Our position, Your Honor, as you had noted, was that she was asked to complete the service a second time because she wasn't fully honest with her domestic violence counselor. She didn't tell them that she had was living with the father of the child who was the person she was engaging in domestic violence with. And so for those reasons, they asked her to do it again. And I don't believe I know according to the proof that she didn't complete that.
So the argument
and
is
it's also,
so is the argument that again goes to the issue of making progress?
yes, absolutely. And in addition, I want just to point out lastly that mother has been engaged in clinical visitation, which is essentially a parenting class, a hands-on parenting class with this child and the youngest of Nino's older siblings. She had been in that program since 2015 and had never progressed beyond eyes-on constant supervision. So, and if there's nothing, yeah, I'm sorry.
I was going to say, anything further?
If there's nothing further, Your Honors, I'll rely on my brief. Thank you.
Very good. Thank you, Counsel. Counsel?
Good morning, Your Honors. May it please the court. Susan Maris, attorney for the child Nino, who's a little over 2 years old and is residing in the same foster care home that he's been in since birth. The family court order was certainly based upon the preponderance of the evidence. The odor in the house is just one factor. The heart of the issue is this mother, she does participate in services, but she doesn't progress in services. She doesn't learn. She has a fundamental defect on how to parent. You cannot put this child back in the mother's supervision when all the evidence suggests she doesn't progress. So that's the real key, whether the odor is so pervasive that there's evidence in the record that when Nino, he no longer has visits in the home, which were supervised because of COVID, but he would come home with that same odor. So to figure that out, it's just one small factor, but maybe it's uncleanliness, maybe they don't shower. I don't know, but for an odor to go on to the child when he's visiting for, I think he had 2 to 3 hour visits. And when he comes home, and not only did he smell from that odor, he smelled from cigarettes. So the father was smoking in the home, even though he denies it. So there's more than the odor. There's the fact that although the mother does participate, she doesn't progress. Therefore, the finding of derivative neglect is clearly based upon the preponderance of evidence and should be affirmed. And as for the father's appeal, because he's on submission, the only points I really want to make are he appealed the disposition, which was on consent, that should be dismissed. And then the other two issues regarding the witnesses and the recusal arguments weren't preserved for this court's review. And then as for the merits, I've already made my argument. Thank you, Your Honors.
Thank you, Counsel. Case 18, Dreamco Development Corporation versus Empire State Development Corporation.
Good morning, Your Honor.
Okay, do we have everybody here? There you go. Very good.
Yeah, sorry, Your Honor, had some technical difficulties this morning. So
we all have those difficulties in this new environment, but that's okay, Counsel. We're here. We're ready to go. Counsel, yes, please proceed.
Oh, I thought that the appellant would be arguing as well.
That's certainly what I meant.
Oh.
Yes, good morning. May it please the court, Kimberly Campbell for defendant Maria Lehman. There is one primary.
Can I just ask, could you go in further to your microphone? I can barely hear you. Thank you.
Oh, yes. Is that better, Your Honor?
A little bit, yeah.
Yeah. Okay. Thank you. So the one issue that the court has to decide today is whether the plaintiff's complaint made out a cause of action for fraud against my client, Maria Lehman. And when you read the complaint in its entirety, I think it is very clear that the elements of fraud were not even facially alleged in the complaint. I know that the court is familiar with the long history, not only of this case, but of the many cases which have been filed surrounding the termination of DePizio Construction Company as the general contractor from the Buffalo Inner Harbor project. But what really bears emphasizing here is the very minimal nature of Ms. Lehman's involvement in this whole chain of events. The contract was awarded to DePizio Construction Company, who, as the court is aware, is not even a party to the present case, in January of 2012. There was, according to the complaint, a long series of disputes between DePizio Construction Company and Empire State Development Corporation and Erie Canal Harbor Development Corporation, who were the other parties to the contract, according to the complaint, from the moment the contract was signed, which continued on for approximately the next 18 months until the general contractor was ultimately terminated in July of 2013.
Counsel, as you know, we're very familiar with the facts. Is there anywhere in the complaint where material misrepresentations that Lehman made is set forth?
No, Your Honor, there is nowhere in the complaint that any material misrepresentations of fact were made. In fact, the complaint affirmatively states that Ms. Lehman never spoke to the plaintiffs. As the court is aware, the elements of fraud are that there have to be a material misrepresentation of fact made by the defendant to the plaintiffs, and that the defendant had to intend for the plaintiffs to rely on those misrepresentations, and that the plaintiffs actually did rely on them. Now, again, the complaint affirmatively states that Ms. Lehman never spoke to the plaintiffs. So there are no misrepresentations made.
If you never spoke to the plaintiffs, does reliance also fail for that same reason?
Yes, exactly, Your Honor. And now what the plaintiffs argue in their brief is that now the plaintiffs don't even attempt to argue that they meet the elements of fraud. Instead, what the plaintiffs do is that they attempt to assert essentially a new cause of action for conspiracy, which was not pled in the complaint. And what the plaintiffs argue is that Ms. Lehman was in a conspiracy with the co-defendants. Well, that argument fails for two reasons. The first being that the plaintiffs cannot use the appellate process to assert a new cause of action. And the second was that even if they could, the first element of a conspiracy cause of action is that there has to be an underlying tort. And if there's no underlying tort, there's no conspiracy claim. And then I would just like to briefly also address my second point, unless the court has further questions on the first point, that there were no material misrepresentations.
Proceed, counsel. Out of the second point.
All right, so the second point is that the cause of action for fraud should also have been dismissed on the grounds that it was time barred.
Was that raised?
I'm sorry, Your Honor, I didn't catch that.
Was that raised below?
Yes, it was raised below, Your Honor, briefly. And that the cause of action is time barred because...
Briefly, what do you mean by that?
I believe that it was addressed in the papers, Your Honor, although it's the primary focus was on the actual elements of the case, and that they had not been established.
Okay, proceed.
Right. So the complaints should also be time barred, or the fraud cause of action should also be time barred because the court, in deciding on a statute of limitations question, has to look to what was actually alleged in the complaint, not to whatever name the plaintiff chooses to label the cause of action by. And as I've just discussed, that there was no fraud that was alleged. There's not even any facial allegations that Ms. Lehman made any misrepresentations of fact to the plaintiffs. And so it is clear that what is actually alleged is a claim for tortious interference with business relations, which was also pled in the complaint, in which the trial court dismissed, because it was beyond the statute of limitations. And I
think we have that.
Thank you, Your Honor. Thank you. If there are no further questions, I will rest on my brief.
Very good. Mr. Isaacs, it is your turn now.
Yes. Good morning, Your Honor. Good morning, judges. Daniel Isaacs on behalf of the respondent, Roseanne DiPizio and Dreamco. I'll be very brief, won't go into the background of this case, as the court is, of course, well aware of the facts of this matter. Whether or not Ms. Lehman's involvement was minimal, we believe that Justice Ogden properly denied her motion, finding that there is a question of fact as to why she prepared the second email in issue and whether it was done for fraudulent purposes. Now, Ms. Lehman's counsel makes much of the fact that she did not speak to Mr. DiPizio. Well, what she fails to state is the reason that Ms. Lehman did not speak to Mr. DiPizio was because she was directed not to by Sam Hoyt. Moreover, when Ms. Lehman was asked to prepare this analysis of the project, she's a well-established engineer with tremendous experience, and yet she knew she was being asked to evaluate a project, but didn't ask for the essential documents required to do so, the contracts, the change orders, etc. All she was provided with was two memorandum prepared for by the defendants, the Lero report, and then the Phillips Leiter memorandum. She didn't ask for anything else. And I would like to direct the court's attention to the two emails, which were page 133 to 134 on the record, and page 142. And in her first email, she marks it as confidential, which is interesting. Why would it be confidential? This is a public works project. There's no confidentiality. And she clearly, if you look at two emails, she completely takes out any reference to Lero. She notes in the first email that she had to investigate another potential problem with the project, but never did so. And just overnight, summarily issues a second email, which was used by the other defendants as part of this fraudulent scheme to wrongfully blame Roseanne DiPizio and by extension DCC for the project's delays. And we believe that, again, the trial court was proper in finding issues of fact based upon the complaint as well as the exhibits that were next there too.
Very good, counsel. Anything further?
That's it, Judge. I mean, the court's has a lot of knowledge about this case. I don't think we need to add anything else than what was submitted.
Thanks very much, counsel. Case 20, Mixon versus Wickett.
That's submitted.
Oh, thank you. Thank you. Case 21, Barnum versus Merrimack. Also, my notes indicate that you are unopposed. Do you want to proceed?
Thank you, Your Honor. I do represent the respondent here today, Dr. Merrimack. We are responding to the plaintiff's appeal from the order granting our motion for summary judgment. I believe the issues are relatively well laid out in our brief. I am, however, here today in case the court has any questions that I can answer.
No questions, counsel. Thank you.
Thank you, Your Honors.
Case 23, Sheets versus Kilbury.
There I am. Good morning, Your Honors.
Very good. Welcome, counsel. Please proceed.
Thank you, and maybe please the court. Your Honors, this is a case regarding summary judgment arising out of a motor vehicle accident. I'm sure you're familiar with the facts. I would just like to begin by framing at least my argument as a bottom line up front. This was dismissed in Monroe County Court on the basis of a serious injury threshold issue, but my position essentially is that this is more of a causation issue. The claimant had a spinal fusion. The carrier had an IME. The IME does corroborate that the claimant has limitations of range of motion and what would be serious injuries, as well as agreeing with the opinion of the treating physician, due to the cervical fusion that she had. The question, of course, becomes is causation, and that's buried a little bit inside of Dr. Molinari's report, the carrier's consultant or the defendant's consultant. The issues at hand are that Ms. Sheets was an older individual. She did have an MRI following this initial accident, and it did show significant degenerative conditions, which would probably be consistent with someone of her age level and group. The most important fact here is that she was completely asymptomatic to her neck. One of the small red herrings in the case was that she had had a very significant, unfortunate, another motor vehicle accident where she was hit head on driving as a bus driver.
Is that the lumbar injury?
Correct, yes. And that does, as argued below, and I will not make too much of an effort to argue 90 of 180 days, the problem with somebody who just had a spinal fusion to the lumbar spine just several months prior to this accident is not going to have many activities of daily living for me to point out as being limited. She was already limited. In fact, she was doing very little other than driving for the very first time following her surgery or in that ballpark. But again, the fact that she sustained such a significant injury previously and that the cervical spine was never mentioned whatsoever, she was 100% asymptomatic as far as at least medical treatment goes. Obviously, older people are going to have pain in their neck once in a while. No need for treatment. This injury occurs, the continuity of the ongoing treatment every several months with Dr. Zeidman, including conservative efforts at first with physical therapy and injections, show that there was a consistent need for treatment up into the final decision where to have the spinal fusion, where at that point she was not showing progress, she was actually going downhill. So again, boiling it down to the very crux of the argument, our position is that this event, whether or not there were pre-existing conditions which were dormant, precipitated the facts that required the treatment, required the surgery, and subsequently resulted in the permanent consequential loss of range and motion and function of the neck. Thank you.
Thank you, counsel. Do you want to address the negligence issue?
Yes, thank you. The court obviously just didn't address that issue because if the case was thrown out, the negligence wouldn't take place. So this was a stopped vehicle. It was a rear end type case. No non-negligent excuse was offered by the plaintiff, and in her deposition, she thought she was driving slower than she was. The photographs of the vehicle in the record show that it was clearly a lot faster than perhaps she may have recalled, but there was no reason whatsoever to blame Ms. Sheets for her running into her, and none offered by the respondent in this case.
Very good. Thank you, counsel. Counsel?
Thank you, Your Honors. Good afternoon. May it please the court. Opposing counsel is correct. This is a causation issue. And I believe it's clear by the medical records, the expert reports and affidavits, and most particularly the cervical MRIs from after the accident that show that there were no objective disc injuries that were traumatically induced by this motor vehicle accident.
Counsel, would you agree it's a little troubling, though, that there's no record of any injury to the cervical area, no complaints? I mean, we often get these cases and you'll have some medical records of complaints of pain or limitation of range of motions in the cervical area that pre-existed. But there's, as far as I can see, and correct me if I'm wrong, there's none of that in this case, right?
No, there's no treatment. She has the significant lumbar history.
No, I'm talking about cervical. Let's focus on the cervical. It's easy.
Yes, I understand that
these cases when you start talking about the different areas of the body. But if we're talking just about the cervical injury, which is what they're complaining of in this case, right? There's no pre-existing injury that we can see. And then subsequently, she has these complaints of pain and limitations of range of motion and goes downhill from there, right?
So there's no pre-accident treatment, but the MRI from 2 weeks after the accident clearly shows pre-existing degenerative changes, and there are no herniations or protrusions.
No surprises, right? You reach a certain age, and those degenerative conditions are going to show up. In other words, it's You look at those MRIs and people are just you're gonna have those. And so that's not an indication of anything other than aging, right?
Well, yes, but it's also evidence of a lack of injury. And then we see new disc herniations 2 years later from the, I believe it's the June 9th, 2016 MRI, which is the first time that the reading radiologist and or Dr. Zeidman sees the disc protrusions, as they call it, at C5-6 and C6-7. Those do not exist.
In our case, counsel, there's no prolonged a period of time before there's complaint from her of pain, discomfort, limitation, range of motion in her neck. In other words, it isn't 2 years later she starts to complain about this and is now trying to relate it back to the accident, right?
There are certain things that she does not complain of. I will admit she complains of neck pain, but she makes no complaints of radicular symptoms until 8 months post-accident. Approximately, that's June 30th of 2015 is the first time she ever complains of that radicular pain. And then it's not until May of 2016 when she goes back to Dr. Zeidman and claims of the clumsiness. I think she said she's dropping stuff at home. So at that point, we're almost 2 years out. That's when he orders the second MRI. And at that time, and only at that time, do they see disc protrusions at C5-6 and C6-7. And that's ultimately what he performs the surgery on. So there was nothing for him to perform a surgery on before almost 2 years post-accident when he sees new findings 2 years after the accident.
I understand. Anything further?
Just briefly on the negligence issue, if the court does get to that, I understand it was a rear end accident and the burden shifts, and I'll rely on my brief, but I do believe a proper non-negligent excuse was given. It was a construction zone. There was a quick merge, and my client uttered the phrase that it was an abrupt stop due to this construction that happened, and she didn't have time to avoid the impact. So that would be the non-negligent excuse required on that issue, should you get to it. But of course, we believe you should not, due to the lack of objective findings on those MRIs directly after the accident.
Very good, counsel. Thank you. We have your argument.
Thank you.
Thank you.
This court will stand in recess.
And we'll go right into conference. My note to the judges.